Dear Chairman Winterstein, dear Volker, dear Chairman of this meeting, dear Mr. Schwanenflügel, dear Vice Chairperson Degener, ladies and gentlemen, dear colleagues. It is a great privilege to give an opening address at this venue to you all, and at the same time introduce myself to you. Since early this year, I've been with the First Division of the Federal Constitutional Court of Germany, reporting on the law of Betreuung and the decision that has just been mentioned. However, I am not responsible for it. This is something that they worked on before I came on board, but I'm sure that there is going to be a few more details on that and an opportunity to discuss it later on. Of course, the Federal Court of Justice also always makes sure that whatever decisions they make become as clear and as broadly publicized as possible. So I was very happy to accept the invitation of my colleagues from Göttingen and my friend Volker Lipp. The Fourth World Congress on Adult Guardianship also provides an excellent opportunity to gain first-hand insights on the law of guardianship and also discuss the problems that it may also create. And I'm also an uncle of a child with legal protection, so this is a matter that is close to my own heart. It is particularly the international perspective that is of greatest meaning when you want to learn for your own legal practice. I'm an international lawyer myself, so the Convention on the Rights of People with Disabilities and what it means for the contractual practice are of utmost importance. Last but not least, this piece of legislation is one of the most cited international covenants. The statements from the commitment of the Committee on the Rights of People with Disabilities has been a great help in interpreting it, but the same goes for the European Human Rights Court. As we've just heard, we live in an aging society, and this means that the importance of guardianship law cannot be overestimated. Since it first entered into force on the 1st of January 1992, German guardianship law has been undergoing constant further development. The contribution by the constitutional law and the Constitutional Court of Justice itself is as fundamental as it is, last but not least, limited. It all bases on the fundamental right laid down in paragraph 1 of the German Constitution that lays out the dignity of every human being towards the state and it's their right to respect and protection. The dignity of all people cannot be relativized. You may be able to relativize all kinds of things, but not human dignity. It needs to be protected and respected under all conditions and circumstances. There's also a personality right that has been developed by the constitutional law, which is also indispensable. This itself is based on the right to free development of the individual. Then there is the right to life and physical integrity laid down in paragraph 2, and if hospitalization is a question, is an option, last but not least, also the inviolability of the personal freedom. It is always the human being that is at the center of all these considerations. Sometimes people may need a legal representative or guardianship, but this may only happen under very strict provisions. The state is charged with protecting the weak, which, however, is only enforceable under very strict provisions. This is the fundamental meaning of the constitutional law. But on the other hand, we have to remember that from these very general criteria, we can only derive very crude criteria for the individual case. The statutory law has to fine-tune all these rights first and also has to come up with the necessary institutions with which the state can then live up to its responsibility. And by state, I do not only mean the government, but also all of us here. I think we all know from our own experience how hard that can be. And of course, the law on guardianship in the German civil code plays an important part in this too. The constitutional law also requires clear medical requirements if any of the basic fundamental rights are to be restricted. I would now like to talk about the decision that the Second Division of the German Federal Court made early this year on forced treatment in forensic commitment. It goes back to the 23rd of March. There was a requirement for clear regulations for hospitalization, and now it has been changed greatly. This also is said to be true for the requirements for the procedure itself. The First and the Second Division have now ruled that forced hospitalization may only be the last resort once the person concerned is not able to consent or to even assess their need for treatment. But this also needs to be combined with certain safety catches, so to speak, in procedural law. The German Court of Justice has drawn from that there is no legal basis for forced hospitalization and forced treatment outside of forced hospitalization. This loophole has now been filled. However, forced treatment can only happen within the framework of forced hospitalization, and there is no such regulation for outpatients that may have to undergo forced treatment. The decree of the First Division dating late July this year didn't change much about that. However, the Senate has derived from the right to physical integrity that the state has the duty of protection for those people who lack mental capacity if they are under risk of severe and prolonged health impairment, and this treatment may also be enforced against the natural will of the people concerned. However, the Senate also made it perfectly clear that this may only happen as a very last resort, and that the natural will has to be taken into consideration as far and as long as possible. However, if this proves to be the problem, if the patient lacks mental capacity and the treatment is promising and will be successful, this is basically the aspect that will override all else, legalizing forced treatment. This is an intervention into the personality right of the individual, because people do not have to live up to standards of functionality, but they also have a right to refuse medical treatment. However, if a person concerned lacks the mental capacity to exercise their own will or to decide whether or not they are in need of medical treatment, or might not be able to act upon that decision, then they might be overruled, because the state has a duty to protect even those. In the case of those that lack mental capacity to discern the need for treatment, or that lack the capacity to act upon that decision, the state may be allowed to introduce the necessary measures. The legislator, however, has to live up to certain regulations and has to put the conditions in place for procedural law. Living wills and wishes that might have been uttered before need to be respected under all circumstances. The will of the person concerned needs to be respected. First of all, however, the principle of necessity also stipulates that the person concerned needs to be persuaded, if possible, of the necessity of the treatment that's to come. Leaving forced treatment as a last resort. Last but not least, I would like to draw your attention to the fact that the German Federal Court also emphasizes the importance of statements and recommendations of the Committee for the Rights of People with Disabilities. However, this is not something that each court can decide themselves. It is something that can only happen within the framework of international law. However, any national court has to take a look at the recommendations of this committee bona fide in order to form an informed judicial opinion. The reporter will also be here on Friday, I'm sure, and will probably elaborate on that. I will be here myself as well. The decisions that are taken in the Senate tend to be taken collectively. It is not only a condoning of what a reporter has already reported. And I can also assure you that we might not always take the decision that would be favored by the majority, but I can also assure you that whatever decision we take, we always try to include all aspects pertaining to personality rights. All those make an important part in forming our opinions, and our consultations tend to be prolonged and very hard, but that's our job. I believe that this meeting is an ideal forum for an exchange of ideas in a spirit of collegiality, and we can probably learn a great deal from each other. In this respect, I hope that this will be a successful and productive meeting for all of us. Thank you.